Welcome to SCOTUScast, Iranian Assets and Separation of Powers Edition. Thank you for tuning in. On April 20th, 2016, the Supreme Court decided Bank Markazi v. Peterson. The Iran Threat Reduction and Syria Human Rights Act of 2012 makes a designated set of assets available to satisfy the judgments gained in separate actions by victims of terrorist attacks sponsored by Iran. Section 8772A2 of the statute requires a court, before allowing execution against these assets, to determine inter alia whether Iran holds equitable title to or the beneficial interest in the assets. Respondents, more than 1,000 victims of Iran-sponsored acts of terrorism, their state representatives, and surviving family members, hold judgments against Iran and moved for turnover of about $1.75 billion in bond assets held in a New York bank account allegedly owned by Bank Markazi, the central bank of Iran. When respondents invoked 8772, Bank Markazi argued that the statute was unconstitutional, contending that Congress had usurped the judicial role by directing a particular result in a pending enforcement proceeding and thereby violating the separation of powers. The district court disagreed and upheld the statute. The U.S. Court of Appeals for the Second Circuit affirmed, and Bank Markazi took its objection to the U.S. Supreme Court. By a vote of 6-2, the Supreme Court affirmed the judgment of the Second Circuit. Justice Ginsburg delivered the opinion of the court, which held that Section 8772 does not violate the separation of powers. Justice Ginsburg was joined by Justices Kennedy, Breyer, Alito, and Kagan. Justice Thomas joined the majority opinion in all but Part 2C. Chief Justice Roberts filed a dissenting opinion in which Justice Sotomayor joined. To discuss the case, we have Eric Zimmerman, who is an attorney at Robinson, Bradshaw, and Hinson, PA. As always, the Federalist Society takes no position on particular legal or public policy issues. All expressions of opinion are those of the speaker. And now, Mr. Zimmerman.
For the sake of disclosure up front, I'll mention that I filed an amicus brief in this case on behalf of Professors Ed Hartnett and Erwin Chemerinsky. Our brief supported the respondents who ultimately prevailed in the Supreme Court, but the views I express on this podcast are mine alone and shouldn't be attributed either to my firm or to Professors Hartnett or Chemerinsky. Bank Markazi presented an interesting separation of powers question. When a case is pending, can Congress enact a statute that applies solely to that case and that effectively decides the outcome of that case? That's the question, and another way to put it is, does such a statute intrude on the judicial power because Congress is, in effect, acting like a court and determining how a single pending case should be resolved? That question arose in Bank Markazi after Congress passed a statute that tried to assist American victims of state-sponsored terrorism in executing on judgments that they had obtained against the state of Iran. For years, those victims of terrorism had obtained judgments against Iran in U.S. courts, but they've had difficulty executing on those judgments against Iran's assets and have run into a number of legal obstacles in doing so. In 2008, some of these victims of terrorism initiated a proceeding in federal court in New York, and that proceeding was captioned under the name of Deborah Peterson, and they sought to execute on about $1.75 billion in assets that were owned by Iran's central bank, Bank Markazi, and that were being held in a bank account in New York. A number of enforcement proceedings brought by victims of terrorism were then consolidated with the Peterson proceeding under a single docket number, and ultimately more than 1,000 victims had their claims brought together on that single docket and were trying to collect on the Bank Markazi assets in New York. Bank Markazi resisted those efforts and asserted a number of defenses. Then in 2012, Congress stepped in and tried to sweep away most, if not all, of those defenses. It enacted a statute that singled out the pending proceeding in New York by name and docket number. The statute provided that it applied solely to the assets at issue in that proceeding, and it provided that the assets would be subject to execution if the district court found that they satisfied several conditions that were specified in the statute. The district court subsequently found that the assets in the case satisfied those conditions, and it therefore ordered the assets to be turned over to the terrorism victims. The case ultimately ended up before the Supreme Court, and in that court, Bank Markazi argued that the statute that Congress had enacted in 2012 violated the separation of powers for two reasons. First, Bank Markazi argued that the statute was invalid because it directed the outcome of a pending case. Second, Bank Markazi argued that the statute was invalid because whether or not it directed the outcome of the pending case, it applied only to that single case. And in other words, it was too specific and contravened what Bank Markazi said is the usual norm that Congress enacts laws of general application. In a 6-2 decision, the Supreme Court rejected both of those arguments and held that the statute was constitutional. Justice Ginsburg wrote the opinion for the court. Chief Justice Roberts dissented, and he was joined by Justice Sotomayor, which incidentally makes Bank Markazi the first case in which the Chief Justice and Justice Sotomayor joined a dissent that no other justice joined, so a unique lineup in this case. The first argument raised by Bank Markazi, that the statute improperly directed the outcome of a pending case, was based on the Supreme Court's decision in United States v. Klein. Klein was decided back in 1872, and ever since then it's really confounded courts and commentators. Klein held that Congress had improperly attempted to strip the court of appellate jurisdiction in that case. But in reaching that conclusion, the court's opinion used a good deal of language and reasoning that seems like it can't possibly be correct. In particular, Klein seemed to say that Congress improperly takes on the judicial power when it, quote unquote, prescribes rules of decision to the judicial branch in cases pending before it. In Bank Markazi, the court agreed with numerous commentators who have argued over the years that this broad language in Klein about prescribing rules of decision can't be taken at face value. Congress often enacts statutes that apply to pending cases and therefore prescribes rules of decision for those cases. Nevertheless, as the court had recognized before Klein and as it's continued to recognize since, and as the court reaffirmed in Bank Markazi, courts are usually bound to follow those newly enacted statutes in pending cases, even if they prescribe rules of decision for those pending cases. Now, there is an exception, and Justice Ginsburg explained that the exception is that courts don't need to follow new statutes in pending cases when the rule of decision they prescribe is itself unconstitutional. So that means courts don't need to follow a statute if it would violate some provision of the Constitution, such as the ex post facto clause or the takings clause. And as the court explained in this case, that was the best way to understand what happened in Klein. The statute in that case attempted to strip the court's jurisdiction in a way that diminished the effect of pardons that had been issued by President Lincoln. So the statute in Klein violated the Constitution's grant of the pardon power to the president, and that's why the court declined to follow it, not merely because it prescribed a rule of decision, despite the broader language in the court's opinion. So as interpreted by Bank Markazi, Klein stands for a relatively narrow principle. That principle is that Congress can't instruct a federal court to decide a pending case in a way that violates the Constitution. Now, as Chief Justice Roberts observed in his dissent, there's no real doubt that that principle is correct. That's ultimately the principle that the court first embraced in Marbury v. Madison. So Bank Markazi reads Klein really to do nothing more than reaffirm Marbury and hold that Congress can't violate the Constitution and it can't use laws affecting the court's jurisdiction in ways that would violate the Constitution and create unconstitutional results. And the court in Bank Markazi therefore rejected the argument that the statute here was invalid merely because it prescribed a rule of decision for a pending case. The court also rejected Bank Markazi's second argument that the statute here applied only to a single case and was therefore too specific to be constitutional. Justice Ginsburg's opinion initially disagreed with the characterization that the enforcement proceeding here was a single case. She explained that, in fact, it was a consolidated proceeding in which numerous cases and more than 1,000 victims had been brought together, so it didn't really make sense to view it as a single case. But in any event, the court further explained that Congress can legislate in very specific ways. it's true that the Constitution does prohibit some forms of specific legislation, such as bills of attainder, which are laws that single out an individual person for punishment. But the court at least seemed to hold in Bank Markazi, although it's not crystal clear, it seemed to hold that so long as a statute doesn't violate one of those particular explicit constitutional limitations, like the Bill of Attainder clause, it's not invalid solely on the theory that the statute is too specific and only applies to one case or one dispute or even one person. In rejecting those arguments raised by Bank Markazi, the court ultimately helped to bring some helpful clarity to the meaning of Klein and Congress's power to enact specific legislation. It's interesting to note, however, that in responding to some of the arguments raised by the Chief Justice's dissent, the majority at least left some interesting questions potentially unresolved. So in particular, Chief Justice Roberts argued that under the majority's reasoning, Congress could enact a statute that says, in the pending case of Smith v. Jones, Smith wins, which he said is deeply problematic, as I think most people would recognize. The majority countered by saying, no, such a statute, under our view, would be unconstitutional. It would be invalid. And the majority said the problem with a statute like that is that it would attempt to compel a result in a pending case without changing the law. In other words, the statute wouldn't supply any new legal standard for the court to apply, and would instead simply instruct the court to enter judgment for one of the parties, which is really an exercise of the judicial power and something Congress can't do. But the court held that the statute in Bank Markazi was different than that hypothetical statute because the statute in Bank Markazi did supply a new legal standard. It provided that the victims of terrorism could execute on Bank Markazi's assets only if the court found that those assets satisfied several conditions that were specified in the statute, which the majority saw as a new legal standard. The problem, as the Chief Justice observed, is that there really didn't seem to be any doubt that the assets satisfied those conditions in the statute. And that meant the statute, in effect, said that in the case of Bank Markazi v. Peterson and the terrorism victims should win. And so the Chief Justice said it really was no different than his Smith v. Jones hypothetical statute. The court disagreed that the conditions in the statute were foregone conclusions and that the district court would find them to be satisfied. But it ultimately seemed to accept that even if it was a foregone conclusion that the court would find those conditions to be satisfied, that the statute would still be valid. And so the difference between the majority and the dissent seems to boil down to the question whether a statute that says in Smith v. Jones, Smith wins, should be treated differently than a statute that says in Smith v. Jones, Smith wins if the court makes a particular finding, and there's no doubt that the court will make that finding, so the outcome is predetermined. The majority appeared to conclude that those statutes should be treated differently, and only the statute that literally directs the court to enter judgment for Smith is invalid. Now, that line certainly seems formalistic, and the court didn't explain in any real detail why that's the right place to draw the line, and why only the statute that literally directs the outcome should be invalid. I think what the court was thinking, or to me it seems like what the court was thinking, is that it would be extremely difficult to draw the line anywhere else, at least without bringing the validity of any number of other federal statutes into question. If the court held that a statute is invalid when it effectively decides the outcome of a pending case rather than literally directing the outcome, it's foreseeable that courts could be drawn into a real thicket of challenges to statutes that apply to pending cases. And it appears that the court may have concluded that even if statutes like the one in Bank Markazi are somewhat unsettling from a constitutional perspective, holding them invalid would really create more problems than it would solve by leading to endless litigation over the validity of these types of statutes. All of that said, I'm not sure that the court's opinion completely closes the door on a ruling that a statute could violate the separation of powers, even if it didn't go as far as literally saying that Smith wins. That's because the court in Bank Markazi, in a few places, emphasized the particular circumstances of the case, and that might have limited the court's holding to those circumstances. So, for example, the court emphasized that it was dealing with enforcement proceedings to enforce judgments that had already been obtained rather than the initial litigation on the merits, for example, between Smith v. Jones. And it also emphasized that this case touched on issues of foreign affairs and that Congress and the President have greater power in that context to deal with the assets of foreign states, and so that may have affected the outcome of this case. So in another context that didn't involve enforcement proceedings or that didn't involve foreign affairs, it's at least possible that the court might draw the line somewhere else and find that a statute like the one in Bank Markazi actually does unconstitutionally direct the outcome of a pending case. I somewhat doubt it would do that and put the line anywhere different depending on the context. And as I read the opinion, I think the court's invocation of those particular circumstances was sort of meant to dress up the result and not really critical to the outcome. But I think that all remains to be fleshed out in the future, and we'll have to see what happens if Congress again attempts to legislate, at least in effect, the outcome of a single pending case.
Thank you for listening to this episode of SCOTUScast. For more episodes of SCOTUScast, as well as audio and video of past Federalist Society events, please visit our website at www.federalistsociety.org/multimedia.